case briefs, and so much more. LSData's got what you're looking for.
In 2016, the Florida District Court of Appeal presided over a unique dispute between a hotel landlord and a tenant in a case dubbed Palm Beach, Florida Hotel v. Nantucket Enterprises, Inc. It all began when the tenant failed to secure required building permits for renovations. Consequentially, the city closed down their restaurant and placed red tags on the doors, signaling a substantial code violation. In reaction to these violations, the landlord decided to terminate the lease agreement and lock the doors, resulting in an immediate halt to the tenant's operations. The tenant, feeling wronged, initiated a lawsuit claiming wrongful eviction and conversion. The jury sided with the tenant, awarding them a total of $10.8 million in damages, $8.8 million for wrongful eviction, and $2 million for conversion. The landlord, unhappy with the decision, appealed it, specifically contesting the amount awarded in damages. The Florida District Court of Appeal revisited the case, putting particular emphasis on the legality of self-help eviction, even when a lease agreement permitted such an action. The court upheld the tenant's eviction as wrongful, affirming the $8.8 million in damages. However, it reversed the conversion penalties, with the rationale being the tenant did not experience property conversion as they claimed. Nonetheless, the case wasn't closed, as the court remanded it for a recalibration of prejudgment interest relating to the tenant's cross-appeal. This case served as a stark reminder to landlords about the importance of following due process when evicting tenants, regardless of what a lease may allow, and to tenants about the fine line between eviction and property conversion.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind, leave the stress of climb.